Judicial review. It's the process by which courts check if public bodies are acting lawfully. In this case, the applicant's housing request was rejected by the Council Housing Association, or CHA. But can they challenge it through judicial review? Let's find out. First, is the CHA subject to judicial review? Yes, it was created by a bylaw under a statute, which means it's exercising public functions, like allocating housing. This makes the CHA's decision public in nature and open to challenge. Second standing or locus standi. The applicant is directly affected by the housing refusal. That gives them sufficient interest to bring a claim, a key requirement. Third, timing matters. Judicial review must be filed promptly and no later than 3 months after the decision. The CHA made its decision in mid-March, but the applicant saw the email in May. Unfortunately, the deadline runs from the date of the decision, not when it was read. Unless there's a good reason, late claims may not be allowed. Next, before going to court, the applicant must do 2 things. First, they need to use the CHA's internal appeal process, if that's available. Second, they should send a letter before claim, which gives the CHA a chance to respond. This follows the pre-action protocol. Now let's look at the grounds for judicial review. Bias is one. If a CHA officer had personal animosity or some interest in the outcome, that's procedural unfairness. You might ask, would a fair-minded observer suspect bias? If yes, that's definitely a problem. Then there's irrationality. For example, if the CHA refused the application just because the applicant could move in with their parents, ignoring their real needs, that might be what's called Wednesbury unreasonable. Another ground is failure to consider relevant factors. The CHA must look at actual housing need and not just follow rigid policies blindly, which is really about misuse of discretion. Finally, lack of reasons. If the email gave no explanation, it could breach the duty to explain decisions that affect basic rights. So, can the applicant bring a judicial review claim? Yes, if they meet the time limit and procedural steps. The strongest arguments are likely bias and irrationality. If the court agrees, it could quash the decision and order the CHA to reconsider it lawfully. Want to learn more about how judicial review works in real cases? Go ahead and subscribe for Legal Explainers Simplified.